Hello, I'm attorney Vince Davis. Today, we are discussing the massive shifts in California tenant law for 2024 and 2025. From eviction reforms to security deposit caps, these changes fundamentally alter the landscape for everyone in the housing market. Legislators have been busy closing loopholes and increasing transparency. Let's start with the Homelessness Prevention Act, or Senate Bill 567. Effective April 1st, 2024, this bill tightened the requirements for no-fault just cause evictions, particularly for owner move-ins. Landlords or their relatives must now move into the unit within 90 days and reside there for at least 12 consecutive months. If they fail to do so, the unit must be offered back to the displaced tenant at the same rent and lease terms. For remodeling evictions, the work must be truly substantial, meaning it cannot be performed safely with the tenant present. Landlords must provide written notice including work descriptions, duration, and copies of all required government permits up front. Willful violations now carry heavy penalties. Landlords could be liable for 3 times actual damages and punitive fees. Next, let's talk about Assembly Bill 12. As of July 1st, 2024, there is a major change to security deposits. California law now prohibits residential landlords from demanding a deposit exceeding 1 month's rent, regardless of furnishing. Small landlords owning no more than 2 properties may still charge up to 2 months, but only if the tenant isn't a service member. This applies to new leases signed on or after July 1st. It does not require refunds for deposits collected before that date. Looking ahead to 2025, Assembly Bill 2801 introduces strict documentation requirements for those security deposits. Effective April 2025, landlords must take time-stamped photos of the unit's condition before or at the start of every tenancy. Upon move-out, they must take photos before any repairs or cleaning and another set after the work is finished. These photos must be provided to the departing tenant along with the itemized statement of any deductions made. The law clarifies that deposits cannot be used for ordinary wear and tear or professional carpet cleaning unless absolutely necessary. Another significant update is Assembly Bill 2747, which focuses on rent reporting and credit building for tenants. Effective January 2025, for properties with more than 15 units, landlords must offer tenants the option to report rent payments. This allows positive on-time payments to help build the tenant's credit history with nationwide consumer reporting agencies. Landlords can charge a fee of up to $10 per month to cover the actual cost of this reporting service. In the realm of eviction procedures, Assembly Bill 2347 has extended the time a tenant has to answer a summons. Starting January 2025, the response period for an unlawful detainer summons moves from 5 days to 10 days. This extra time is crucial for tenants seeking legal advice and preparing their formal written response to the court. Senate Bill 611 addresses so-called junk fees that have plagued many rental agreements in the past. Landlords are now prohibited from charging fees for paying rent or security deposits by check or other traditional methods. The law also bans fees for serving, posting, or delivering any legal notices that are required by California law. Regarding personal property, SB 7112 allows tenants to store and charge e-bikes and e-scooters in their units under specific safety standards. Batteries must meet safety certifications. Landlords can only ban in-unit storage if they provide secure outside storage. Assembly Bill 1418 now bans crime-free housing ordinances that used to mandate evictions based on mere calls to law enforcement. This prevents entire families from being displaced due to the alleged actions of a single member or simple police contact. For victims of domestic violence, SB 1051 requires landlords to change locks within 24 hours of a written request. If the landlord fails to act, the tenant can change the locks themselves and seek full reimbursement for the cost. From SB 567 to AB 12, the theme of 2024 has been strengthening tenant protections and landlord accountability. In 2025, the focus shifts toward operational transparency, especially regarding security deposits and credit reporting. For landlords, compliance means updating your notice procedures and ensuring your photo documentation is impeccable. For tenants, these laws provide powerful tools to challenge unjust evictions and protect your hard-earned security deposits. The extension to 10 days to answer an eviction summons is a significant win for access to justice in California. Keeping detailed records of every interaction and document is more important now than it has ever been before. The legal landscape is shifting rapidly. Understanding these nuances can be the difference between winning and losing a case. Laws like AB 2747 finally give tenants a way to turn their largest monthly expense into a credit-building opportunity. We've covered a lot today, from eviction protections to the end of hidden junk fees and rental agreements. Navigating these laws requires attention to detail. Make sure you are using updated forms and compliant notice periods. Our goal is to ensure that everyone in California housing is treated fairly under these new, more stringent regulations. Remember, no-fault evictions now require much stricter proof of owner move-in or substantial remodeling. And starting this year, most landlords cannot ask for more than 1 month of rent as a security deposit. Finally, stay prepared for the 2025 photo documentation and rent reporting requirements coming your way soon. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together.